Thank you. All right, this is City of Ducktown versus Polk County.
Morning, Your Honor.
Are the parties ready?
I think so. And I have some preliminary issues that I would like to address, and we addressed them last night with Miss Ingram, but I don't know how much was conveyed to Your Honor. We had a hearing for an injunction in May, probably a little less than a month ago, or right at a month ago. And at that time, and I should have known better, but I was overly optimistic that the parties would be able to come to an agreement in the interim. We have not been able to do that. The court set a hearing for today, and I think kind of to push the parties to hopefully get this thing resolved. But we've not been able to do that. Mr. Logan filed an answer and a motion to dismiss yesterday at about 4:06, I think is when I got it. Given that I just got the answer and a motion to dismiss, I don't really feel like we're going to be able to hear this case today. Also, looking over everything and in light of the fact that we can't come to an agreement, I have some discovery that I'll need to conduct. I think I may even need to amend my petition to add a specific claim regarding double taxation. And so I would ask to continue the hearing. I don't think it'll take a long time to get all that discovery done and have it reset for a hearing, but I do think it needs to be continued. I think that we're going to be able to go forward today if this issue goes up to the Court of Appeal. And I think given the kind of the ambiguity in the law it might, I would like for it to be more ready than what I think it will be today.
Mr. Logan?
Judge, our position has been from the time of the initial hearing on the application that there is no real dispute of facts between the parties with reference to the authority of Polk County to impose a fee under the circumstances. It is true that up until this past year, the county of Polk has not imposed a fee, but made that imposition. The other municipalities, as is alleged in the answer, have signed the agreements that are applicable to them, and we have merely asked that Ducktown pay the fee, which they agree is reasonable in their answer. And the question is solely the power and authority of Polk County to impose a fee, and there appears to be no question under the statutes which we provided to the court. The issue which the court raised at that hearing was that the court did not have enough information because the court did not know if we had a plan which had been approved by TDEC. We have the Polk County executive here prepared to testify. There's been really no dispute about that issue. The issue of double taxation would be a new issue, but under the facts as acknowledged in the answer, and we can strike our motion to dismiss for failure to state a claim because, interestingly, governmental entities are immune from an adjudication of cost for filing a complaint which does not have merit. Under the motion to dismiss, as the court knows, private parties, the court can assess attorney's fees against the losing party on a motion, but that's not applicable under that rule. So it does us no good to persist in the rule because the facts are without dispute. We would ask the court to go ahead and proceed. As the court noted previously, this is a very important issue for Polk County, and the only dispute with reference to the order was whether or not the court ordered that they pay prospectively from and after that date, or they paid from January, which is when they had agreed to begin to pay the fee, and there's little dispute about that. The court did set the case for hearing on the merits for today. We are prepared to proceed to have testimony that they do have a plan, that they have operated that plan for years, and they are in full compliance with TDEC regulations, and the county executive is prepared to testify to that. Also, that he was present in December meeting of the City Commission of Ducktown, and that they voted to approve the fee. and the agreement, there was some question raised about the paragraph 8, which the court has and is set forth in the complaint. The interlocal agreement is a very, very significant matter, has been agreed to by the other municipalities. It provides for notices of default and typical opportunities to cure, as we find in those kinds of agreements in most instances. The question of whether or not we would unilaterally and without any cause terminate the agreement is, I think, a prospective impossibility, but because every contract requires that there be a reasonable conduct, and there are specific provisions within the interlocal agreement which give rise to the cause for termination. A difference of agreement that might arise in the future as to the reasonableness of the fee if the cost of providing the service of transporting to disposal facilities by Polk County. There are provisions in this interlocal agreement which was approved. Admittedly, they were not pleased, the Ducktown City Commission, with paragraph 8, but it's a very reasonable provision, and we continued to provide the service with the understanding that they had approved the fee to be paid beginning January of 2021. Those are all facts that the court is set forth in their initial complaint, which they filed, and so we are prepared to answer any questions the court stated that you did not know enough, and I recognize we put a very important matter before the court on the issuance of the temporary restraining order. So we would just ask the court to rule on the undisputed facts or hear the testimony if the court requires any additional testimony other than the admissions by the city of Ducktown in their complaint.
Okay. Mr. Grant?
Your Honor, and
let's assume that Mr. Logan, as he said, would strike his motion to dismiss. The answer has been filed. I gave you all time for the hearing. It doesn't appear to be that any facts are in dispute. So tell me why you would need a continuance.
Sure. Unfortunately, Your Honor, there are facts in dispute, despite Mr. Logan's contentions. Otherwise, Polk County has relied upon one statute and two provisions of that statute to assess a fee. The first one of those, in that statute, we talked about it before, Your Honor, is 68-211-835. The first part of that statute that Polk County seems to be relying upon allows a municipality or a county that has a municipal solid waste disposal facility to assess a tipping fee. And Polk County says that's what it's doing. But, Your Honor, Polk County doesn't have a municipal solid waste disposal facility. That's what Bradley County has. Polk County takes that to Bradley County. So that provision of the statute does not allow Polk County to assess a tipping fee. And that's really what they're trying to assess here, Your Honor, is a tipping fee, not a fee, a solid waste disposal fee. It's a tipping fee, and they can't do that. The second part of the statute that they're trying to rely upon allows a municipality to provide an assessment of a fee to provide for solid waste disposal. The issue with that is that a separate tax? Because for 25 years, no fee has been assessed against anybody in the county. It's just simply come from their budget. Now, this is a separate fee that they're adding on, and the statute's pretty clear. It's got to go into a separate account. It's got to be reasonably based, and it's got to be used just for this issue, just for the providing of the convenience center. And we don't have the information that we need, and I asked for it in an Open Records Act request, and I haven't gotten it all, but we don't have information on whether this is going to a separate account, whether the money that they've gotten from Copper Hill or from Benton is going to a separate account, or if it's just going back into their general account. If it's going into the general account, Your Honor, and I can cite a couple of cases, that's a tax. It's not a fee, despite what they call it. And I think we've got to have some discovery on that to figure out what they're doing with the money that they're getting from Copper Hill and Benton, and that's what they're trying to do with the money that they want to get from the city of Ducktown. is it really a fee or is it a tax? And I think it's a tax. The folks in Ducktown who are county residents have been paying their taxes, and for the last 25 years, that's been fine. Now Polk County, and they actually admitted to me in the Open Records Act request, Your Honor, that they have saved $233,000 in their sanitation budget, and thus they can't say that they need more money because the costs have gone up. They're actually paying less than they were paying before. So again, it looks like this is a tax just to fill the coffers, to replace some of the money that's being expended. The folks in Ducktown, as citizens of Polk County, are already being taxed for that. It's been provided for 25 years. This appears to be a double tax, and I think we need to address that issue before we go forth with the final hearing. And I can pull up part of the open records request. I sent it to the county executive. He responded, and some of the response says this has got to go to the county clerk. I sent it to the county clerk also pretty quickly after I was told that, but I haven't gotten that response back yet. And so,
issue of taxation or double taxation been pled at this point?
It is not, but I think it's an issue in the case because that's the reason, that second reason under the statute. Ducktown's position is that results in double taxation to the citizens of Polk County, and so I think I'll need to amend my complaint to add that in. And Your Honor, this whole thing's only been on file for 30 days, and so I've never had a case where I've actually tried it within 30 days of actually filing the complaint. And I know the court set a quick hearing date for us, but I think that was in part because we'd asked for an injunction, and the county had responded to that. Looking at the statute, I would also point out, Your Honor, looking at the statute, what Polk County did is actually they said, you can't use the facility because you've not paid and because you won't enter into an interlocal agreement. If we look at the statute and in the best light for the county, they can require Ducktown to pay a fee, and we dispute that, but that's in the best light to the county. They can't stop them from actually dumping there because they didn't sign an interlocal agreement. The city of Ducktown has tried, and it's another fact issue that's going to come out. The city of Ducktown tried to pay the fee, and the county wouldn't take it because they didn't sign the interlocal agreement. But that statute doesn't have anything allowing the county to require an interlocal agreement for the city to use that facility. And again, those are issues that I think we've got to flesh out more in discovery. And again, I will be, after receiving the answer and looking at the motion to dismiss, I need to amend the complaint. And I think that all those issues need to be addressed. It certainly makes more sense to do it at the same time. The other option, I guess, is I could non-suit it and refile it. But that doesn't seem to be a really good use of anybody's time since we've already got these issues out there.
Well, this is what I'm thinking at this point, is that I will allow you to amend, but I will dissolve the restraining order. And so you all will begin paying the fee. We'll reserve the issue of arrearages. I'll give you a short time to amend and tell me when you want this thing, how long you'll think you'll need for discovery. Because I think you've just admitted Polk County has the right to charge the fee. Now you're talking about the interlocal agreement, unless it's a double taxation.
Yeah, no, Your Honor, what I was saying is, at best, Polk County can establish a fee. I don't think they can because I think it's a taxation issue, and so I don't want the court to think that I'm saying Polk County can assess the fee.
Right, that's what I just said. They can't charge a fee unless it's a double taxation issue. And they get out of that issue by keeping all of this in a separate account.
They may, but I don't know. The problem is I don't have that information to see if they're doing that or not, Your Honor.
All right.
But I guess my thought going forward, and I'm appreciative of the court on that, if we pay the fee, even if we haven't signed the interlocal agreement, can the city of Ducktown utilize the convenience center? Because I think that's what the statute, I think that's...
As long as you pay the fee.
Okay.
I'm dissolving your restraining order.
Right. But I guess, are you keeping it in effect to the extent that the county cannot force the city of Ducktown to sign the interlocal agreement before using it?
Yes, they can't. You all can't. I can't create an agreement, and that's another interesting issue to me is whether we know they can charge a fee to people who use the convenience centers. The question is, do they have the ability to require an agreement, and if so, what are the provisions of that agreement? And I haven't been shown anything about what the statute says the parameters are, I certainly would assume, and that's always a leap right there, that it would be a reasonable agreement, whatever that is. And apparently that's where the disagreement is between you all, is what is reasonable. So I'm not saying that the statute's complete, but I'm saying that we really haven't looked at it from that standpoint at this point.
Sure. No, yes, Your Honor, I agree. And so I think, just to make sure I'm clear on it, so we don't have an issue with the order, the temporary injunction is
dissolved,
except to the extent that as long as the city of Ducktown pays the agreed upon fee, you can continue to utilize the facility during the while we're doing discovery.
Your Honor, yes. The statute requires that these funds be segregated. If there is an allegation that they are not, we will put on evidence today that they are segregated. We know that, and the statute specifically provides for that. So the question of whether or not I know the courts typically are not in the business of writing contracts for parties. I've never seen them do that. I have seen the courts interpret provisions as reasonable. And the question of whether or not the termination from that is the termination of the service. Every Ducktown citizen in the court can see that even if the taking of by the Polk County at its convenience center is terminated to the city of Ducktown, Polk County residents from wherever can still use the convenience centers. That's what they do, is they use the convenience centers. Now, we are pleased to have offered this in the past, but the cost of the delivery as a part of the disposal system existing in Polk County has gotten to the point that where you have this delivery system, the legislature understands that that increases the operation of the disposal of the property because of the trash. And that's why we've got this. Now, if the court wants to interpret our proposed interlocal agreement as being unreasonable, which says that if the agreement is terminated, there are provisions regarding the termination throughout the interlocal agreement, opportunities to cure, then we will abide during the pendency of whatever is necessary or appropriate, the court's decision that if we terminate it, we can maybe even terminate the right of Ducktown residents to dispose things? No, we specifically provide that it will still be available to the citizens of Ducktown. But this delivery, which increases the amount of trash disposal, contrary to the supposition, there's no evidence or no allegation. It is an allegation that perhaps you get the same amount of trash if you have a pickup system within the municipality. I suggest to the court that that's not a part of any of the statutes or that supposition, nor is there even an allegation that it is a lesser amount if they pick it up and deliver it. That's the only thing that I know that there's really a dispute of fact about. Now, we understand the court's ruling. If they want to raise the issue of double taxation, we think that can be responded to within 15, 20 days, however they wish to do it.
How long do you think you'll need if you amend your complaint quickly, Mr. Grant?
I think we're going to do it today, Your Honor, to amend the complaint that filed. I think, can we have 3 months for discovery?
No, I think that's way too long. This is not a big issue. I mean, it is what it is. If the fee is going someplace else, I don't know why you can't find that out in 30 days.
I may be able to, Your Honor, but I guess I don't want to be in the position to come back like I did this time and say, unfortunately, I've not had a chance to get it. We were pretty quick about getting our open records request out. I couldn't send discovery to Mr.
If you're delayed by their not getting you the information, that's a motion to compel.
Well, but the problem is, Your Honor, if I don't get 3 months, I've got 30 days to send discovery. And then if they don't respond, I've got to cooperate with them, and then I've got to get a motion to compel and get that heard. And so if our hearing is 90 days out, that barely gives us time to get all that information.
I disagree. If you don't get the information timely, then file a motion to compel and set it in 5 days. That's what the civil procedure provides. I have a feeling they're going to give you whatever that you ask for that's reasonable. So I'm going to reset this to August 19th for hearing on the merits, whether you've amended or not.
Okay, that's fine, Your Honor. I think that's fair.
All right, Mr. Logan, anything else?
Your Honor, the court has not addressed the agreement to pay the fee commencing January 1. You're reserving that, as I understand it.
Yes.
All right. We will be making requests at the trial, as the court would know, for prejudgment interest.
Absolutely.
The minimus sum of money.
Yes.
How much money are we going to spend trying this case? The court doesn't have
Mr. Logan, I ask people that all the time.
You generally have a good response to that. Thank you, Chancellor Greenis. I hope you're doing well.
I am. Y'all have a good day.
Take care. Bye-bye.
Bye-bye.